Oh,
I'd like to mention item number 7 in the list.
yes.
My lord, in this, we were directed to file an affidavit. We have received the para-wise comments, my lord, yesterday. We
Okay.
request some time to prepare the affidavit. It will come after 3 weeks, my lord, by the opening, reopening.
Who appears for the
I have
petitioner?
taken consent. My friend appears.
Okay, heard MS.
And Decca, your lordship.
Learned counsel for the petitioner.
I am appearing for the statement.
Mr. B.D. Goswami, learned additional advocate general. Arunachal Pradesh submits that he has received instructions and prays for
3 weeks time now
3 weeks time to
to file affidavit.
Praise the Lord. It's 3 weeks.
March only.
Wait, please, your lordship. Lordship, I victim is item number 8 to 12 file.
Yeah. What do you want?
My lord, this matter may come in the month of January, my lord. Please for the petitioners, my lord. I have taken consent.
Lordship, I'm only thing, Lordship, I'm praying for a fixed date, Lordship, old matter.
Is it you are appearing in all the matters?
Lordship, not the first one, Lordship, the rest four I'm appearing. This
Okay,
over I'm not appearing.
okay. Heard Mr.
And gotten, Lord.
N. Gautam, learned counsel for the petitioner. In writ appeal 148/2021. On request made by SKTL, learned standing counsel.
My lord, I am appearing for on behalf of my lord AZ, my lord, for water issues, my lord. All the respondent, my lord.
Standing counsel, Water Resource Department. When do you want? Gautam?
Any date in January, Lord.
Give us this.
Lordship,
Please don't. After Bihu or before Bihu?
After Bihu, my lord.
21 year old.
21st.
Bless you.
Lordship, my victim is item number 13 of today's
Oh.
list, my lord.
Hmm.
My lord, this matter is, I'm mentioning on behalf of a friend of Mizoram, my lord. Let the matter come up in January on a fixed date, my lord. He was unable to come today.
Okay. on
January
request
22,
made on
madam.
behalf of the learned counsel for the appellant. List the matter
January 22, my lord.
on 22nd January. That's not a hearing day.
Maybe 23, my lord.
20. Okay.
23 is a hearing. my lord. Always, my lord.
Lordship, and item number 2, Lordship, according to last one, Lordship, we are supposed to file a rejoinder, Your Lordship.
Hmm.
But unfortunately, Lordship, the authorized signatory was in an offsite location, Your Lordship. Hence, the affidavit could not be filed on time, Your Lordship. May I pray the matter may come on 18th, Your Lordship.
Gautam, what is there to hear in this petition?
Otherwise, Lordship, we got two simultaneous
Read
proceedings, Lordship. Lordship, otherwise the blacklisting is gone, Lordship. The two order merges. So how if the main order is gone, Lordship, the second order
You
cannot
can
stand.
challenge that. And then the show course also, you never met your reply to the show.
Lordship, at that particular point of time, Lordship, will you bring it out on an affidavit, Your Lordship, that we are under insolvency proceeding, Lordship. So at that point of time, our company was going through that, and we have got an order of the arbitral tribunal also, Lordship.
Okay.
So at that point of time, we are not taking issue.
The development is the automatic fallout of the termination order. So automatically. it will-
Okay, and request made by N. Gautam, learned counsel for the appellant. How much time?
18th, Your Lordship. 18 December.
List the matter on 18th.
Your Lordship.
18th December is December.
Lordship.
Okay. 18th December.
I'm appearing for the respondent.
MS Arbora, learned standing counsel
HIDCL.
appears for the NHIDC.
All right.
Lordship.
This is now the case I have read last.
Wait, please, your lordship. Lordship, I beg to mention for listing of a writ appeal on Monday, lordship.
What is the urgency for Monday?
Urgency, lordship, is the termination from service without following the due procedure, lordship. That which is the learned single judge has been informed, and against that the writ appeal has been filed, lordship. Monday, lordship.
Okay.
Obliged.
Item 1 of daily list order.
Respondent 5.
5, my lord.
Yeah, please.
Yes, my lord.
You have any objections for the?
There is some objection I have to file on the
You want to file objection?
Well.
How many days delay?
76 days delay, you know. No notice was received, Your Honor.
Oh.
Well, in deciding the writ petition, respondent number 5 of the writ petition never received any kind of notice, Your Honor. In fact, the law Zimma order reflects that deemed service was recorded, Your Honor.
You want to file objection here? 76 days delay.
Hello.
Then we can
Well,
hear the
yes.
What, Mr.
Wasim Raja.
W?
ASIM
Oh, ASM
Raja.
Raja, learn accounts for the petition, for the applicant.
One more prayer, Your Honor. In between the authority concerned preparing for fresh interview of the Anganwadi, Workers.
You submit when you are hearing the written.
I have already submitted pilot different IA, Your Honor. If the
Huh? Oh.
interview is happen, Your Honor.
Why are you disturbing me when I'm?
No, sorry.
What, Mr.? No. A Raja or something. Azim, Wasim Raja. Learner counsel for the applicant. Also heard
K.U. Ahmed.
social welfare. MSRB Boral, understanding council, social welfare for the, okay. Government advocate for the respondents.
1 PM.
1, 2, 3, and 4. And Mr. K.
K.U.
Ahmed Leonard, counsel for the respondent number 5. Stop. Follow. By this application, the applicant is praying for continuation of 76 days delay in filing the connected appeal. The learned counsel for the respondents have no objections in continuing the delay. Para, this court, we have also considered the cost shown in the present application, and we are satisfied. Accordingly, delay of 76, accordingly, the delay in filing the connected writ appeal is condoned. Register is directed to list register the writ appeal and list the matter in its usual course.
In between, my lord,
In the writ appeal in the connected I. Register.
my lord, memo of appeal, my lord, may be. Sorry. Obliged. Obliged.
3 and 4 hearing.
These two appeals prepared by the department. Usually in the meantime, on 6/8/24, the monetary limit for High Court has been increased to 2 crores and the value of the present appeal are below 2 crores. So in view of the lordship, the notification, case may be closed. Lord. So there is a provision that in pending case also this notification will be applicable.
So it will be before the system.
Lordship? Yes, Lord. When the appeal was prepared, it was fall under the limitation. Now Lordship, in view of this notification,
2 crore.
2 crores and Lordship close to, it says that instructions applies only to legacy issues pertaining to relating to central excise and service tax and will apply to pending cases.
Here, what is the value?
In 135, in one
In the
case,
first
35
case,
lakhs.
it is 39 lakhs and the second case it is 1.20. It is below the- Lordship, in view of this notification, they want to withdraw this matters.
Okay. What not? I can't read this Hindi.
What is the heading? Can you read it as?
Lordship, it is Bharat Sarkar Vitt Mantralaya, Government of India, Ministry of Finance, Revenue Department,
Okay, Mr.
Legal
S.
Cell.
Here,
CBIC.
Learned standing counsel. You're the
And the Senior Standing Council, CBIC,
senior standing counsel.
Central Board of Indirect Taxes.
Central Board of Indirect Taxes. Submits in view of the notification dated
6/8/24.
6/8/2024 issued by the Ministry of
Finance, Lordship.
Finance. He pressed for withdrawing this appeal.
In view of the notification, Lordship.
Oh, that's why I'm saying
Lordship.
he pressed for withdrawing this both the appeals with liberty to approach the appropriate form. That will so.
No, Lordship,
There is-
there
Press
is
for withdrawal.
only the substantial cause law may be agitated in appropriate cases.
Okay, that's why I'm saying.
Good.
So accordingly, comma. MS,
ML go. ML go. MS ML go.
got it. Then the council appeals for the respondents.
Responded.
Writ petition is accordingly disposed of on withdrawal.
Much.
That's it.
Both the writ petitions are accordingly disposed of on.
5,
This one.
My lord, in this case, senior government advocate did not will be a permitted. He is in leagues in some other matter. Can it be taken next week? Next week, matter.
Come date in January, your lord.
Okay, heard Mr. N. Gautam and the counsel for the petitioner. On request made on behalf of Mr. D. Nutt, then the senior government advocate for the state respondents. List on. In the month of January.
In the month of January.
In the month of January 2025.
6,
Please, your lordships, my lord, records were called for in this matter.
Lordship, in this case, records were called for. I have made a communication with the department. The record has been sent to Ceylon. Somebody is coming with record. So it may take some time. But it may take some other date.
Okay,
Maybe after Bihu vacations then, my lord.
heard MS Chakravarti as a counsel for the appellant. On request made by SCKL, Learned Standing Council, Customs and Central Access.
Lordship, custom.
Customs and Central Access. When do you want?
After Bihu vacation? So that, my lord, in the meantime, records.
Is the matter in the month of January 2025.
Much.
14, Fourteen,
It is a appeal by the department. Lordship, actually, the question of law were framed. Lordship, two questions were framed, Lordship, here.
Just asking how long will it take?
Mr. Sir, how much time will it take? It will take some time.
It will take some.
It will take some time.
Yeah.
Thorough time, but
It takes some time,
it will take some.
because this is an ad hoc bench.
I think it will maximum both sides maybe 45 minutes, not more than that. So unnecessary blood.
I have to place some documents and.
Not documents, below the finding, this is the pure Milo Lotsmisi questions.
Maybe Lordship, but
No, I understand. Let me just, I'm not disturbing you. Below the appeal is to be decided on such a question of law. And Lordship may see the questions which have been framed. And thereafter, you also will see the finding of the tribunal.
on
And there are-
24/5.
There are at least 20 judgments I bought, Lord, which are all says that when the tribunal has come to finding that all the genuineness and the certainty proved, this is a question of fact and High Court will not interfere. You also may just finish it up, my lord. Even if the ad hoc bench is there, my lord, it will be over.
I have no objection, Lordship. I'm ready
Let
to
you
place.
start, my lord, it will be over. I will not take more than half an hour, my lord, 30 minutes.
Proceed. Proceed. Okay.
Lordship, on 24/5/2023, two substantial question of law were framed.
24.
24-5. 23.
Question of law. Okay.
First question was whether the learned tribunal erred in law in holding that SEC has discharged its burden of subsistence of the identity, credit worthiness, and genuineness of the transactions involving receipt of share application monies. The number two was whether the learned tribunal was justified in deleting addition under section 68 of the share application money of 30 crore 69 lakhs 54,888 received from Santidham Marketing and Orchid Finance Limited. If I repeated a synopsis. So here the question was with regard to two companies, Arcade Finance, Lease Company Limited, Private Limited, 1 crore 75 lakhs, and Santidham Marketing, 32 crore 94 lakhs. An addition was made by the assessing officer of rupees 30 crores, 34 crore 69 lakhs and all, under section 68 of the Income Tax Act. Now let's say we come to section 68.
You leave.
Issue will be asking that first, before going into the act and all, what the issue was. Hello. Mr. Kayal, what
Not
was the issue?
The issue was lordship, this amount of 30 crores, 34 crores was added by the assessing officer because the SEC was failed to prove the genuineness and worthiness of this amount.
Transaction.
Yes, lordship.
That amount, the genuineness was not proved.
Not as per the assessing officer, it was not proved. Then they prepared appeal. In appeal, it was reversed. Against that, we approached tribunal. Tribunal also come against us. Then we approached this honorable court. And two subsequent question of law were framed.
And therefore, this amount of 38 lakhs was
34 crores.
crores was added.
Added.
Not at all.
Now it is been deleted, but assessing officer added this amount. Now we have come for appeal for consideration. Place before a lordship.
So therefore, the first substantial question is whether the burden was discharged or not.
Yes,
This is the first substantial
this is the main question of law.
about the genuineness of that particular transaction. Because perhaps Dr. Sarab's contention was that genuine without. What was your contention, Dr. Sarab?
My contention that the genuineness, creditworthiness, everything has been proved. The tribunal has come to conclusion after a detailed discussion that the burden has been discharged and the creditworthiness and this genuineness of the transaction has been proved.
Okay.
Now, this amount were not credited this year. This amount were unsecured loan in the last year. And in the current year, only it was converted into share application money. So, in fact, it is not a fresh transaction also. I will before the judgment.
So the genuineness of this was doubted by the SSC.
Yes,
Assessing officer. Appellate authority said they are not proved. Against that, they went in appeal before the tribunal, and tribunal also reversed through.
Yes, there is a finding of
there before.
Yes, tribunal also said it is proved. So now
for that we are before a lot. Two companies were involved in this case. I've given in my note, lordship. Lordship, my first that is section 68. Here, any sum is found credited in the books of SEC maintained for any previous year. The SEC offers no explanation about the nature and source thereof, or the explanation offered by him is not, in opinion of the assessing officer, satisfactory, the sum so credited may be charged to income as the income of the SEC of that previous year. Then provided that where the SEC is a company, not being a company in which the public are substantially interested, and the sum so credited consists of share application money, share capital, share premium, or such amount by whatever name called, any explanation offered by such SEC company shall be deemed to be not satisfactory unless A, the person being resident in whose name such credit is recorded in the books of such company also offers an explanation about nature and source of such sum so credited. Such explanation in the opinion of the assessing officer, the aforesaid has been found to be satisfactory. Provided further that nothing contained in this first proviso or second proviso shall apply if the person in whose name such referred to therein is recorded is a venture capital fund or venture capital company as reflected in. So let's see under section 68 economic submission, it is the duty of the SEC to place on record that the transaction which he added in his account, there are worthiness and genuine lots. Now let's see. The assessing officer doubted about the transaction made by with respect to two company. One is Orchid Finlis Limited Company and other is Santidham Company. Let's see. In my note, the source, because they have to, not only they have to prove the source, but source of the source they have to prove. Because let's see, there is a link between the transaction lots. So here it is found that the source of Orchid Finland Company invested in the capital cement company is appellant let's see, from sale of share of Darkwell Dealers Private Limited, source of sorts. On verification, it is seen that the Darkwell Limited Private Limited is a stock of register of companies. Of the register of companies, it is found that the Darkwell Dealers Limited got fund from the sale shares of VRC Technology Limited, whose income is very low. In contrast to of the very high price of shares. Lots may come to page 34, para 34, page 41. Lot. This is a finding of the assessing officer.
Page 34.
Page 41 lots. Paragraph 30.
Para?
Para 34, page 41. I'm sorry, lots.
Something is wrong. Right. Oh,
34. Mr. Kyle, page?
Lots. There's some mistake in pagination.
Where does the assessing officer's order start from?
It was,
Yes, I think it starts from page 15.
it is page 15 lots. Lots
Paragraph?
page 55. I'm sorry, page 55. Paragraph 34. Merit roll. As per reply to notice under section 133(6) received from the investor company Orchid Finlays Private Limited, it is seen that the funds amounting to rupees 1 crore 75 lakhs 54,848 have been invested by the said company in the SEC company as share capital and share premium out of the funds received from the investor company Mrs. Orchid Finlays Limited as a result of sale proceed of the equity shares mentioned below. Now let's see, there is a table where lots of name of the company is Darkwell. Date of receipt, amount received. This is reflected from their books of accounts. Now, paragraph 34.2. It is seen from the ROC database that the company Darkwell Dealers Private Limited have been struck off by the ROC and the income of the company TRC Technology Private Limited is very low, which does not justify the high price at which its shares have been sold by the company Orchid Finley's Lease Private Limited. Moreover, from the extract of the bank statement received in response to notice under section 153(6), it is seen that the funds are received by the company Orchid Finley's Limited and immediately transferred to the bank account of the SEC company Goldstone Cement Limited. These are the typical features how shell companies operates in order to provide accommodation entries. All these just hints that the transactions are bogus in nature, carried out only to accommodate unaccounted money of the group in garb of share capital and share premium of the SEC company Goldstone Limited. So this is the finding of the assessing officer, Lordship. The Darkwell company, Lordship, it was already struck off of the rest of companies, and from whom they have purchased, that their income was also very low.
But the share price was
Very low. And share they have shown their account is very high price.
when was it struck off?
Lordship, that finding is not there. Then Lordship, finding of the appellate tribunal to that effect is at page 577. 577. Orchid Court. The heading is Orchid Private Limited, assessment year 1718. Amount is rupees 1,75 lakhs. We note from page 1057 to 1144 of the paper book of detail of Messrs. Orchid Finley's Lease Private Limited are set out. Peruse the reply furnished by the shareholders in response to the notice under section 133(6) of the Act shows that the shareholder is a registered non-banking finance company holding certificate of registration number so and so, which regularly file its return of income and assessed under the jurisdiction of ITO Ward number 31 Guwahati. It is noted that the shareholder had actually advanced loan to the SEC of rupees 2 crore 55 lakhs in the financial year 15-16 pursuant to a loan cum share purchase agreement dated 11/1/2016. Copy of the said agreement and board resolution approving the same is found placed at page 1065 to 1069 of the paper book. We further note that the said company has provided detailed breakup of the loan advance along with bank statement evidencing the advancement of loan. Copy of which is enclosed at page number 1073 to 1070 to 1073 of the paper book. It is noted that the net worth owned fund of the company was in excess of rupees 2611 lakhs, and therefore it is evident that the company had sufficient net worth to justify the loan advance to the SEC. The detail of sorts of loan advance to the SEC was also provided by the shareholders, which is found placed at page 1060 to 1062 and 1074 to 1080 of the paper book. It is noted that the source of the fund of the shareholder of the advancement of such loan was mainly the proceeds of 1 crore 95 lakhs 50,000 received on sale of investment holding in Messrs. BRC Technology Private Limited and Paras Money Planning Developers and Messrs. Darkwell Dealers Private Limited, detail of which along with the copies of sales bill are found placed at page number 1070, 1080 of the paper book. In the relevant financial year 16-17, Mr. Orchid Finley's Private Limited did not pay any face sum to the SEC company. From the document available on record, it is noted that the SEC, by board resolution dated 4/5/2016, had exercised their right available under the loan agreement to convert the unsecured loan into equity shares. Having regard to the fair market value of the share determined in accordance with Rule 11 UA of the companies, allotted 4,04,761 equity shares at rupees 63 per share to these shareholders. Copy of the allotment letter issued by the SEC are found placed at page number 1063 to 1064 of paper book. Having regard to these facts, we therefore note that there was no fresh credit received by the SEC in the relevant year 17-18 from Orchid Finleys Private Limited. It was the case of the it was a case where the unsecured loan has been converted into equity capital by way of journal entry. In absence of there being any fresh credit received during the relevant year, the provisions of section 68 of the Act would not have been invoked or applied in the assessment year 17-18. For this, we find support in decision of the Honorable Calcutta High Court in case of so-and-so has rightly held that no addition was warranted under section 60 of the Act in relation to conversion of loan into equity to the extent of 1 crore 75 lakhs. In paragraph 3, even otherwise, it is noted that the explanation regarding source of funds to the married.
Yes.
Subpara 3, even otherwise, it is noted that the explanation regarding source of fund to extent of rupees 1 crore 95 lakhs was payment received from Darkwell Dealers Private Limited. It is noted that AO choose to believe the source of source to the extent of rupees 119 lakh 95,152 and they sell out a sum of rupees 1 crore 75 lakh 54,000 so and so. We find that no reason were given by the AO for believing some sums or disbelieving some sums in relation to same source of funds. Even the learned CITDR was unable to throw light on this apparent irrational action of AO. In such scenario, when the AO is found to be satisfied with the source to the extent of 19 lakhs 95,000 paid by them, the action of not accepting balance rupees so and so cannot be unintended. For perusal of the Alice case trail prepared by the AO in relation to Orchid Finleys Limited shows that it was source of Darkwell Dealers Private Limited, where cash deposit of the account of the payers to extent of 97 lakhs 67,000 was found. Hence, going by the chart, suspicion, if any, gets raised for the source of Darkwell Dealers Private Limited and not the SEC. There was no evidence whatsoever brought in record by the AO to show that the cash deposit made in the account of the proprietary concerned represented unaccounted money provided by the SEC or any evidence regarding nexus with the SEC. We thus find that this case trail extracted by the AO in his order raised doubt, but due to lack of any adverse materials to connect the SEC with the proprietary concern, no adverse view can be taken against the SEC. For the reasons discussed here in the foregoing, it is held that the SEC has discharged its own substantially the identity, creditworthiness, and genuineness of the transaction with Orchid Finance Limited and source fund. Lordship, paragraph 4.
Then going by procedural, the explanation is provided.
Lordship, discussion by the learned tribunal with in paragraph 4 clearly demonstrate that source there was a doubt. And as per Act 68, it is the duty of the SEC to prove the source from where he has created amount has been credited the account of the present respondent. With regard to
Mr. Gal, prove or offers explanation.
yes, Lord. Yes, it is their duty to offer
Offer the explanation.
Lord. But the assessing officer, Lordship, as I read the finding of the assessing officer, it is believed and they fail to prove, and it is the Lordship that the Darkwell, the source of the Darkwell, the company was already struck up from the registered company, and the value of the source was also very low. So just to accommodate the entries, this transaction were shown, Lord. And as recorded by the assisting officer, all these were bogus company, Lord, shell company. Unless trail can be find out any amount shown by the SEC, that cannot be accepted. And, it was rightly added by the assisting officer with regard to Orchid Pinless company. Now, Lordship, with regard to Santidham Marketing Private Limited. Lordship, may please to peruse my note, the second para. As far as the share capital received from Santidham Marketing Limited, rupees 32 crore 94 lakhs is concerned, the source of Santidham Marketing got fund from sale of various unquoted equity shares, actor from names of sorts from whom the Santidham Marketing Limited received funds. No further details were provided. Lordship may come to finding of the assisting officer.
At 56.
Is it page 57, 35?
I'm sorry, Lord. Yes, Lord, page 56. Paragraph 35. Out of the total sum invested in the SEC company by Santidham Marketing Private Limited, sum of rupees 32 crores 94 lakhs, it is invested after receiving the same on account of sale proceeds of investments in unquoted equity shares of companies to various companies. However, no further details regarding sale transactions were furnished by the SEC, except the name of the company to which the shares were sold. Confirmations from few such companies and experts of their except for the bank account statement where it is seen that they have received funds from their companies and immediately transferred the same to Santidham Marketing Limited. Moreover, some of the companies to which the unquoted equity shares have been sold have not been regularly filing ROC return, and some of them have been struck out by the ROC. The discussion made in the foregoing paragraph paras and the detail given herein above clearly shows that the transactions regarding the raising share capital were anything but genuine. Every single transaction as mentioned above smells foul as elaborated in the foregoing discussion. Moreover, the SEC has contended with the help of various case laws in its response dated 28/12/2019 to show the cause notice dated so-called notice dated 27/12/2019 that capital has been brought into the SEC company by three promoters groups led by certain individuals, whose cases are also open from the undersigned, and that since the SEC has established the identity of the persons entitled entities who have made the investment in the SEC company, further assessment and addition, if any, on account of non-genuineness of the source of fund to be made in their in hands. However, it is important to point out the two things in this regard elaborated as under. Firstly, a person is recognized by PAN in the eyes of the Income Tax Act 1961. Every person is a separate entity responsible for their own financial state of affairs, filing their own separate income return. Since companies are also separate persons under the Income Tax Act 61, their finances are liable to be tell separately. As far as the matters under the Income Tax Act 1961 are concerned, their finances, omissions, and commissions cannot be attributed to any individual in ordinary circumstances just because their individual manages or control of the company or in shareholder of the company. Secondly, even though the funds were brought in by different promoters through their group companies, the said funds were ultimately utilized by the SEC company, thus making the SEC company the ultimate beneficiary of the funds infused. The funds are from unexplained source. The beneficiary is the only person on whose hand the impugned credit ought to be taxed. Moreover, the investors who brought the money are also stakeholders in the SEC company. Whatever liability accrues to the SEC company is liable to be ultimately shared directly or indirectly by the investors in proportion to their respective shareholding, since it would affect the overall profit of the SEC company and hence the share of profit of its shareholders. So the only logical thing to do in such case is to tax the beneficiary as per law. Last but not the least, the SEC has contended that the case trail prepared by the department is for a very small amount of funds and runs into several layers. However, it is to be noted that the case trail is indicative of general trend and layering is the standard manner in which their entire accommodation entry cycle is operated. In view of the above discussion, the foregoing paras, the content of the SEC, that the treatment of unexplained credits or unexplained money as income in the hands of the investors is deemed untenable and is treated as duly disposed of. In view of the above discussion made herein above, the following amounts are liable to be treated as unexplained credit in the hands of the SEC company during the relevant year, added as unexplained credit under section 68 in the hands of the SEC. Then amount is calculated. Then paragraph 14, in view of the above circumstances as discussed herein above, that taking into account the various details, it is submitted by the SEC. The income of the SEC for the relevant assessment previous year is complied as follows. Then amount was added. Then what's the finding of the tribunal? Page 579.
Yes.
579. J. We note from page 1145, 1266, the paper book, the detail of Mr. Santidham Marketing Private Limited are set out. It is observed that the AO has issued notice under section 133(6), dated 27/11/2019, on this shareholder requisitioning several details and inter alia requiring it to substantiate its source of fund out of which it paid the share application money to the SEC. Perusal of their response revealed that the shareholder belonging to UFM group of the company, promoters of the SEC, and it engaged in business of promoting and marketing cement and trading of poly bags. The shareholder in GST registration number so and so is regular filed the return of income and is assessed under jurisdiction of ITO Ward 2 of Calcutta. The shareholder has explained the strategic business objective behind infusion of the share capital into the SEC company for the reason that it was the last leg of the company's and commissioning of its cement plant. It is noted that the investment was made at the fair market value compound in term of Rule 11 UA of the rules. Copy of the valuation report is found placed at page number so and so of the paper book. Therefore, the specification regarding share premium is then fulfilled. It is noted that during the assessment year 2017-18, the SEC has received share application money of rupees 55 lakh and all from Santidham Marketing Private Limited. The application money is aggregating rupees 22 crore 68 lakhs and so. The AO has accepted the identity, creditworthiness, and genuineness of this transaction, but choose to dispute the sum of to the extent of rupees 32 crores 94 lakh. We find that no reason were ascribed by the AO for believing some sums are correct and disbelieving some part of the transaction from these shareholders, particularly when similar documents in as much as even the explanation regarding source of funds were furnished by the shareholders in same manner as sought by the AO under the cover of the same letter furnished in response to AO's notice under section 133(6) of the Income of the Act. The AO has instead made a bold assertion that some of the source of funds remain unexplained without giving any cogent basis or reasoning whatsoever. When confronted with these facts, even the learned CIT was unable to explain this irrational action of AO in such a scenario, when the AO is found to be satisfied with the identity, creditworthiness, and genuineness of the shareholders by action of accepting share application of rupees 22 crores 68 lakhs and so paid by them. His action in not accepting balance sum of rupees 32 crores and 94 lakhs is held to be untenable, unreasonable, irrational, being arbitrary. From the audited financial statement furnished, which are found placed at page number 1180 and 1195 of the paperwork, it is found that the company was having sufficient own fund in form of the capital and free reserves to tune of 46 crore 42 lakhs as on 31/3/2017, which is sufficient to cover the cost of investment made by the shareholders during the relevant year. As regard the source of fund, it is noted that the company had placed on record a copy of bank statement for relevant period at page number so and so of the paper book. On examination of this statement, it is taken note that there is no deposit of case and all transactions have been made through proper banking channel. The detail of source fund received by the SEC were also provided by the shareholders in the manner as prescribed in notice under section 133(6) of the Act, which is found placed at page number so and so of the paperwork. It is noted that the source of shareholders was primarily deposited from channel partners and for sale of investment holding, details of which along with PAN and address are found placed at page number so and so. Sri Dudherawala pointed out that the Santidham Marketing Limited was an associate concern and that the director of the shareholders and the SEC were common. He invested our attention to the details of the director of the shareholder, which is available at page number 115 of the paper, from which it is noted that Sri Vishal Jain, who is also the director of the SEC, perused the statement of Sri Vishal Jain, which was recorded under oath by AO on 28/11/2019, shows that the director had also affirmed the transaction between Santidham Marketing Limited and SEC, and nothing adverse came out from his statement. When inquired about the source of funds of the shareholder, the director stated that the shareholder was engaged in business of marketing of clinkers and cement in North Bengal, Bhutan and Nepal, and that the name, address of the PAN of the payers had been provided by the AO, so that the AO can make inquiries from the respective source. It is also noted that upon instance of the AO, the director collected and furnished various supporting documents, namely, which includes invoice, bank statement, as well as confirmation from the payers of the shareholder in support of source funds under the cover of his letter dated 21/12/2019, which is found placed at page number so and so of the paper book. Having perused the same, we find that the SSC had furnished relevant evidence in support of the source fund, and then even the AO was unable to point out any defect nor any falsity or infirmity in documents submitted before him. It is also noted that these shareholders was also subject to income tax scrutiny under section 143(3) of the assessment year 2017-18. Perusal of the assessment order, copy of which at page number so and so of paperwork, shows that the AO, the shareholders, did not draw any adverse inference regarding sorts of investment made by the shareholder in assessing company. in the circumstances when the source of fund of of the investor has been accepted by to be genuine by the AO of the investor, we hold that the AO in the present case was unjustified in holding the source of funds remain unexplained. In regard to the aforesaid facts, we find that not only did the SEC discharge its onus of establishing identity, creditworthiness, and genuineness of the transaction, but source fund was explained. So this is the finding of the tribunal. Now, Lordship, some case laws were south, but tribunal has deferred with the finding, Lordship, that I am placing. Paragraph 11.14, page 582. Very good. In the light of the above, we will now proceed to examine whether the decision of the Honorable Supreme Court in case of Municipal CIT versus NRA Iron Limited relied upon by the learned DR is apt in the facts and circumstances of the present case. For this, let us so examine the principle laid down by the Honorable Supreme Court in case of Principal CIT versus so and so, and whether it is applicable to the present facts of the case or not. In decided case, the SSC company received share capital and premium of rupees 17.6 crores, 60 crores in all from 19 parties, 6 from Mumbai, 11 from Kolkata and from Guwahati. And the shares at face value of rupees 10 were subscribed by the invested company at a premium of rupees 190 per share. The AO made the addition of rupees 17.60 crore after carrying out various inquiries as under. 1. To verify the veracity of the transaction, the notice were served 3 investors company, namely so and so, but no reply was received. 2. The address with respect to the company, namely Real Court Private Limited, was not correct. Then 3. The notice could not have been served on the 2 investors company, namely so and so. 4. The summation made by the 9 companies were received. However, they had not given any reason for paying such huge premium. 5. The details share purchased and amount of the premium were not specified by certain companies, namely so and so, so and so. So then 6. The addition to the above, AO found that out of the 4 companies at Mumbai, 2 companies were found to be non-existent at address furnished. With respect to the Calcutta company, notably appears nor they did produce any bank statement to substantiate their allegation investment. Guwahati company, Spot Seat Limited and Novelty Sensor were found non-existent at the address given. D. None of the invested company appeared before the AO. It was in the light of the above respect, fact of it was held that by the Honorable Apex Court that the SEC company failed to discharge the honors required under Section 60 of the Act. However, in the case in hand, we find that the SEC and all the shareholders had discharged the honors casted upon them under the provision of 68, which has been elaborated in the preceding paragraph. And let's see, it was discussed, and the tribunal has referred with that the facts of this case and the case decided by the Honorable Supreme Court are different. Lordship, now I'm placing that judgment for consideration of the Lordship.
Okay with proceeding with this matter? And we both have authored similar benches. So on that we may, if you think.
If I place the finding of the AO as well as the tribunal, Lordship. Lordship has seen that how they have proved there. Lordship, paragraph 8 onward.
Going to take some time. Carol, I think it's going to take some time. We'll list it some other day because both of us we've got parted matters in single benches, so we'll list it. What is the standing counsel?
CPT.
For the appellants, as well as Dr. Sharaf, senior counsel. For the respondents.
I think he has only completed only one judgment is being placed. My lord, it's 11:30 only. If your lordship just gives 45 minutes, I think it will be over, my lord.
So the problem is, both of us, we've got partnered matters.
My lord, it will be, hearing will be over because he's only placing one judgment and thereafter, my lord, three
How
judgments
long
are.
you're taking?
I'll place some paragraphs of the judgment.
That's all, my lord. His arguments are over. His lordship will give 45 minutes, my lord. It will be over unless his lordship will keep pending. If your lordship so is not inconvenient to your lordship.
What do you say? Shall we proceed? Exactly.
Because my arguments are, short and simple, my lord. When your lordship see, the question which is being framed, if your lordship just looked into it, perversity of the order is not in the question of law. It's not a question which has been raised before your lordship. Now, when the perversity of the order is not a question of law, then the Supreme Court as well as the various high courts have said that the genuineness and creditedness, all these findings, these are pure findings of fact and the High Court will not interfere. Now, here, my lord, the tribunal has, by giving, appreciating all the facts, has come to the conclusion that genuineness, creditworthiness and identity of the cases have been proved. Under such circumstances, my lord, whether Section 260A and substance question of law arises or not. Now, on that, at least 10 judgments are there, including Supreme Court, that no, the High Court will not interfere. My lord, now, my learned friend is now trying to appreciate, my lord, in the way of normal appeal. But this is an appeal on the substantial question of law. Now, appreciation of the evidence, my lord, whether the genuineness, creditworthiness, these are all factual things which have to be determined by the tribunal. And the tribunal, in a speaking, not a cryptic order, tribunal has discussed all the issues and thereafter has come to the conclusion. He is citing one judgment only, my lord. If you also consider me, I will just hand over the, my lord, the comparison along with some paragraphs of your lordship and hearing will be over, I think. Because my thing is only that, my lord, this is a finding when it has been arrived at by the tribunal, the creditworthiness, identity and genuineness have been proved. Then the courts have said that it is pure question of fact, no question of law. And more particularly when the perversity is not a question which has been raised. So if your lordship is not inconvenient, half an hour, I think, my lord, your lordship may. Otherwise, my lord, again, it will go to January and
No, we'll fix a date on Tuesday. We'll take it up.
not.
No, we're not keeping it as a part. We'll fix it on Tuesday and then we'll dispose it of.
No.
If you have some urgency in the matter,
Urgency, my lord, I'm not. My lord, income tax appeal, there can be any urgency like because it order in my favor. I was only thinking, my lord, at least something can be disposed of, my lord. The matter came up for last number of occasions. And lordship has at least heard the entire argument of my learned friend. And I will take at least 20-25 minutes, my lord, that will be over.
okay.
If your lordship just have some time, can spare 20-25 minutes, my lord.
Okay. We can do that. Let us hear it. Let them file written arguments.
I'll just give the compilation of paragraph numbers, my lord. I will be very
No,
short.
along with that, you give your written arguments.
Well, I'll give the time, also, and it will be, my lord, I'll also place. And the short arguments, if you'll also permit me, the paragraph number where it has been held, that creditworthiness, genuineness, when it is decided by the tribunal, it is pure question of fact.
In fact, the AO, it appears from the tribunal's order that the AO has accepted the genuineness of that transaction. There is in one paragraph, however, doubted the
Well, that's why he says that
2 crores.
he says that I doubt on the basis of
Yes.
doubt, my lord, he cannot do it.
Otherwise, the identity and the genuineness that he had
My
accepted.
lord, they appeared, the shareholders themselves appeared before the authorities. And they appeared, they said, yes, we have given it. The capacity is there. Now he says that such amount, how it can come and all those things, there is a doubt. Now, on the
Correct.
basis of doubt, my lord, and more particularly, Lord Supremacy, they are all income tax assessees.
Yes, in fact, that also they have not changed anything.
No. So, my lord, it's not so. And on the basis of doubt or something, my lord, you will also be aware. one
Well,
can-
it is specifically said here, it's paragraph 580. The AO has accepted the identity, creditworthiness and genuineness of the transaction, but
So-
chose to dispute some to the extent of rupees 32 crore.
Yes, sir.
Out of 56,
Yes,
34 crores he has accepted.
And now the substantial question that this court has to answer is whether the tribunal erred in law in holding that the SSC had discharged it.
Yes, Lord. That is
the
our.
purpose
AO has already
AO Lordship, he is doubted about the amount which
Doubting.
he has been attained. And he has given finding to that effect also.
Doubting will not do, my lord.
In both the
We don't need to go into just see this question. Yeah.
Well, a creditor, well, debtor, well, how, what he can prove? If I take a loan from someone, I can say that, my lord, he is the person who has given me loan. It is books of account, it is there, everything is there. Now he has, wherefrom he comes and explains that I've given it.
Okay, KL, give your citation and the paragraphs.
Lordship,
Sure.
paragraph 8 to 15 of the judgment. I've given that.
You have given the
Although-
citation? Yes.
Paragraph
Supreme
8,
today.
yes. The judgment of Honorable Supreme Court Lordship.
Para?
Paragraph 8 to 15. Although tribunal has relied on this judgment, but they differ.
Hmm. Okay.
This is on the owners, how to prove.
Yes.
Anything else? Yes, Dr. Sharaf.
Well, from the order which my learned friend has read, the tribunal's order, it is very clear that the tribunal, by a speaking order, by considering all the facts, has come to a specific finding that creditworthiness, genuineness, and identity of the persons has been proved. Now, if that has been proved, then whether it will be your lordship sitting into 60A of the Income Tax Act by deciding substantial question of law will reappreciate the evidence to come to a conclusion whether the finding of the tribunal is perverse, more particularly when the perversity is not a question before your lordship. The substantial question of law is not there. Now, your lordship may just see, my lord, page 1, paragraph 5. Page 5, my lord,
Of your compilation
comparison, my lord.
page?
Page 5, it is
Oh.
Supreme Court decision,
Oh,
para 11, my lord. A perusal of the question hardly gives an impression that the said question involves any question of law, much less a substantial question of law. In the ordinary course, what we have stated above would have sufficient for the disposal of the appeal. However, the approach of the High Court in this case has been in total contravention of the law laid down by the High Court in curtain of decisions. This court has repeatedly held that the power of the High Court to interfere in second appeal under CPC is limited solely to decide the substantial question of law. If at all the same arises in the case, it has been deprecated the practice of the High Court routinely interfering in the pure findings of fact reached by the courts below without coming to the conclusion that the said finding of fact is either perverse or not based on any material or facts. So, kindly note it, my lord. Now, you lost me see para 14, my lord. Interference with the concurrent finding of the courts below by the High Court under Section 100 CPC must be avoided unless warranted by the compelling reasons. In any case, the High Court is not expected to reappreciate the evidence just to replace the finding of the lower courts, even assuming that another view is possible on the appreciation of the same evidence. That should not have been done by the High Court, as it cannot be said that the view taken by the appellate authority has no material. Now, next case, your lordship may see, my lord, it starts with page 7 and page 9, my lord.
What?
Page 9, relevant part at page 9, my lord.
para?
Para 6. The High Court has upset the finding of fact recorded by the first appellate tribunal, taking a different view, merely on reappreciation of the evidence in the absence of valid and acceptable reasons to say that the findings recorded by the first authority should not be sustained. Either they are perverse or unreasonable or could not have been supported by any evidence. Now we will also again note in Milord that it can be only when it is not perverse or not supported by any material or evidence. Now the perversity of the question case is not there before your Lordship, Milord. The High Court neither framed a substantial question of law, nor is any such questions indicated in the impugned judgment I required under CPC, the approach of the High Court so and so. So when the perversity of the case is not before your Lordship, Milord, the court Lordship will not, Milord, examine the reappreciation of the evidence, and in any case, Milord, the reappreciation of the evidence is not a question of law. Your Lordship, see, Milord, page 11, it starts in page 12. Para 9, Milord. In effect, the question whether a particular entry in the account book is genuine or not, or whether the assessee is able to show its source, is a question of fact. In other words, it only involves appreciation of the evidence tendered by the assessee pursuant to a query made by the revenue. It is for the assessing officer to accept the explanation or for the note. No doubt the first appellate authority as well as the second appellate authority are also empowered to examine the factual background of the issue with a view to examine whether the explanation offered is reliable, adequate, or proper. But that exercise the High Court in the third appellate authority cannot do it by virtue of the specific language employed in section 260A of the Act. Your Lordship, may kindly see below page 14, relevant part of page 15 below. Para 6. A mere perusal of the aforesaid paragraph would indicate that the tribunal went into the factual aspects of the case and having examined the factual documents brought on record at the instance of the SSC in support of its bona fide of the transaction in question, recorded a finding of genuineness of the transaction. In other words, the tribunal was satisfied on the fact that the transaction in question is not bogus, not genuine. It could be entered into by the circumstances appearing, and there is no reason for entering into SSC with the business of the company. In our opinion, the aforesaid finding is a finding of fact. This court cannot upset such a finding of fact in appeal filed under section 260 of the Act. As a matter of fact, the question whether a particular transaction entered into by SSC with a particular person is genuine essentially is a question of fact, and therefore, once such a finding is either way recorded by the tribunal, then the same is not liable to be interfered with the High Court unless so and so. Lordship, see page 20, page 18. It starts with page 17. This is Delhi High Court judgment. Page 18, Milord. The last 3 lines. It is thus pleaded the tribunal having ignored the relevant factors germane to the determination of the question, genuineness of the transaction is finding based on irrelevant materials is perverse, and therefore, Milord, something is missing, Milord. A substantial question of law does arise from the impugned order. We do not agree. Admittedly, the aforesaid finding of fact is factual. Therefore, the only question of consideration is whether such a finding could be said to be without any evidence or material or is contrary to the evidence on record. There is no direct nexus between the conclusion of fact and the primary fact upon which the question is based, so and so. Thereafter, you'll also kindly see Milord, para 9, the last 4 or 5 lines. Or I may read the paragraph, Milord. In the present case, as noted above, the tribunal's finding, which is essentially factual, is based on cogent materials highlighted by the Commissioner of Income Tax Appeal. The Commissioner of Appeals had even gone into the extent of examining the bank accounts of the 2 companies from where the checks in question were issued, and found that there were numerous transactions of deposits and withdrawal, and whenever the checks in favor of the SSC were issued, there are sufficient balance available. If the pertinent note that this was not a case of the assessing officer that any amount credited in the account of the companies a direct or indirect nexus with the SSC company. In this case also, Milord, the tribunal has come to a specific finding that, Milord, the funds were available. Now we'll also kindly again see, Milord, at page 20. This is also a judgment of the Rajasthan High Court. I will take your lordship to page 23. We are of the view that the present appeal does not involve any substantial question of law. The Learned Tribunal has categorically held that the SSC has produced all the relevant documents, document evidence to establish the genuineness of the transaction, and there is no contrary evidence to doubt the correctness of the evidence produced by the SSC, and therefore treating the transaction to be purchase and sale of the same is not justified. Further, the tribunal has also relied upon the decision of so and therefore it said the no question of law. And SLP against this judgment has also been dismissed. Now, I will also kindly see, my lord.
You have that dismissal order.
Already mentioned in the same order, my lord, you'll also see in the same judgment at page 20. At the headnote below, the Supreme Court has dismissed the SLP. As you also got in, Lord, at the bottom of page 20.
Yes.
Now, my lord, I will take your lordship to page 24.
Yeah.
This is a judgment of the Supreme Court, my lord, where the review petition was filed. And your lordship may kindly see, my lord. I will just one paragraph is there.
Page.
Page 20, 24, I'm sorry. We have perused in so and so, we find the tax effect is so and so, lordship may pass over and may come to next page, my lord. Page 25. Thus, the CIT appeals allowed the appeal of the SSC, stating thus that the entire disallowance in this case is based on third-party information gathered from the investigation wing of the department, which has not been independently subjected to further investigation, verification by the assessing officer, who denying opportunity cross-examination of the appellant, who had prima facie discharged the initial burden of substantiating the purchase through various documents, including purchase bills, transportation bills, confirmed bills of the accounts, and fact of payment of the amount and weight registration of the sellers and their income tax return. In view of the above discussion in totality, the purchase made by the appellant from so-and-so is found to be acceptable, and the consequent disallowance of the addition so-and-so is there to be delivered. ITT by judgment dated relied upon the same reasoning and dismissed the appeal of the revenue. Likewise, the High Court by the impugned judgment affirmed the judgment for the concurrent finding of fact, which had not been shown to be perverse, and therefore dismissed the appeal, stating that no substantial lectures from the impugned order. The review petition was dismissed. Here again, you will also see the question is perversity. I will also make again see, my lord, page 26, and relevant part at page 32. This is also a judgment of the Supreme Court, my lord. Para 13. At page 32. In this case, the SSC had given the names and addresses of the elect creditors. It was to the knowledge of the revenue that the said creditors were income tax SSCs. Their index number was in the file of the revenue. The revenue, apart from issuing notices under section 131 at the instance of SSC, did not pursue the matter further. The revenue did not examine the source of the elect creditors to find out whether they were creditworthiness or where there could be advanced the elect so-and-so. There was no effort made to produce the elect creditors. In those circumstances, the SSC could not do any further. In the premises, if the tribunal came to the conclusion that the SSC had discharged the burden that lay on him, it could not be said that such a conclusion was unreasonable or perverse or based on no evidence. If the conclusion based on some evidence on which the conclusion could be arrived at, no question of law arises. Here, my lord, in this case, 131 notice was issued. The creditors appeared and they confirmed that yes, we have given the loan. The credit witness was also proved. In that case, my lord, before the Supreme Court, 131 notice was issued and they have not appeared, they have not proved. Even then, the tribunal came to finding that it has been proved. And Supreme Court said that it cannot be said that anything unreasonable is there in the finding of the tribunal. You also kindly see below page 33 at page 40. Para 11, my lord. Or may I read para 10. It is not in dispute that the above additional money is found credited in the books of the petition company. the petitioner has offered explanation and the amount created were advances against the future sale of the goods and discharge the source. Section 68 of the Act, however, does not stop the advancing of the explanation about the nature and source of any sums created in the books by the SSC. The assessing officer is also required to certify that the explanation offered by the SSC is acceptable and or so and so. The facts as found are clearly indicative of the source being not genuine finding, which has been specifically recorded in the proceeding. When the law has given the assessing officer discretion and it is the satisfaction upon which genuineness has to be decided, his inference on the basis of facts, in our view, is a finding of fact, and as held by the Supreme Court in so and so, finding on the question of pure fact by the tribunal are not to be disturbed by the High Court on a reference unless it appears that there was no evidence before the tribunal upon which a reasonable man could have come to a conclusion to which they have come, and there is no there is so even when the High Court could on the evidence have come to a conclusion entirely different from that of the tribunal. It is well settled that a finding of fact can be reviewed only on the ground that there is no evidence to support it or it is perverse. Moreover, when a conclusion has been reached on the appreciation of the number of facts, whether it is found sound or not, must be determined not by considering the weight to be attached to each single fact in isolation, but by the assessing the cumulative effect of all the facts in the so and so. So, my lord, in this case, the assessing officer has given 4 paragraphs and said that tribunal, by writing 20 pages, by examining each fact, has come to the conclusion that all the 3 conditions have been proved. Now, if all the 3 conditions have been proved, my lord, in my humble submission, my lord, this is a pure question of fact, and more particularly when the even perversity question has not been raised, but even perversity question would have been raised. Then also, my lord, you will also examine whether any person reasonable instructed in law could have such a conclusion, come to such a conclusion or not. Now, my assessing officer himself said it was in doubt whether on the basis of doubt a person can impose the tax and bring it to the income, my lord. When the shareholders themselves appeared before the income tax officer and said, yes, we have given the amount. It's not a case, and they were the income tax assessees. It is reflected in their accounts. How it can be said that something is reflected in their accounts from where the money is coming? Now, my learned friend was saying, my lord, that where from they got it and where from they got it. My lord, if somebody goes to bring the money from someone and ask him that where from you got the money, first you prove him, nobody is going to give the money in credit. If I go to someone to bring a loan and I ask him that you give your balance sheet, etc., where from you got the money, and prove the person's the creditworthiness who gave the money, whether any reasonable person will show his accounts to show that where from he got the money and whether that person has a creditworthiness or not. Now, what type of if the persons were not genuine, they should have added to the income to the accounts of the creditor who has given the money, who says that I've given the money. If he has no undisclosed income, it should be added to his income. How it can be added to my income?
These are matter of facts which the tribunal and the appellate tribunal has already considered.
Completely. And not by a cryptic order, by a speaking order, by examining each facts. So in my humble submission, my lord, the questions which have been framed by substantive question of law are not a substantive question of law at all. These are called pure finding of fact, and the appeal is activities. And I will submit a written submission below before your lordship. This is the short point before your lordship. So
A matter of fact, question of fact. Take an evidence, it's not a case of no evidence. So apparently there is no perversity. And there is no problem for the same person. Hands will be tied. On that basis, they have to make a proceed. No, sir.
No need for written argument.
So we need some because they're not. If he wants, he can give it. We need to keep it.
You want to keep it CV or
Yes, sir.
CV? Okay.
Sir, just one clarification. I want to place sections 260A,
A.
subclause 4.
Yes.
Subclause 4. The appeal shall be heard only on questions so formulated, and the respondent shall at the hearing of the appeal be allowed to argue that the case does not involve such question, such question, then provided that that nothing in this subsection shall be deemed to take away or abridge the power of the court to hear for reasons to be recorded the appeal on any other substantial question of law not formulated by it, if it is satisfied that the case involves such question. This is-
Question of law.
Yes, sir. Even if it is not formulated, because my learned seniors are good, that if you lordship all that these questions will be found were not substantial question of law.
This is akin to section 100 of the CP.
Yes, lordship.
Ultimately, it has to be a question of law.
No, lordship, that is there. But my submission is that this section does not preclude your
Yes,
lordship from hearing.
If it involves, it can be.
Yes,
The Lordship has always developed the power to frame any substantial question of law.
Mr. Ezekiel,
And it is substantial question of law, my lord. Here,
and standing counsel, CBD. Good afternoon, as well as Dr. Sarah, learned senior counsel assisted by Mr. BK Bora. Learned counsel for the respondents.
within 1 week, my lord, I will find the motions finished.
Hearing conclude, just for this. 1 week,
You give it on Monday.
I'll try to, my lord, put some. I'll try it.
Monday, give it to the bench clerk.
My lord,
I'll also file my returns. Yes. Much.
I'm highly obliged, my lord. Such a voluminous, my lord, at least. I know.
slowly. My lord, I think it will be short order. Yes.
One of the issue that calls for consideration with your lordship is whether the UGC regulations are binding on the state in recruitment or and selection and recruitment of college teachers and librarians. That is the issue, madam. The Honorable Single Judge has held that if it is not adopted, then it is not
Binding.
not binding. But the Honorable Single Judge has also held that it has been partly adopted, which is not correct, my lord. I am asserting that binding. And my lord, I will be relying on the affidavit of the UGC, which says that, my lord, it is binding. And also, my lord, there are 2 division bench decisions of this honorable court saying that it is binding based on the, my lord, certain decisions of the honorable Supreme Court. This is my brief plea.
My lord, today, my lord, Mr. K. Gogo is in court number 17. Some part hard matter is going on. So, if possible, I am seeking a little accommodation, my lord, for today.
This has been pending for a very long time.
So, pending for the
Hmm? And the selection is also going on the basis of the, my lord, notification, which was challenged before the honorable Single
They
Judge.
will give you a fixed date. Short date.
Let it be in January, my lord, 1st week of January or 2nd week of January.
You give your convenient date.
One day then.
Go to. But Mr. M.K. Chaudhary, London Senior Counsel, assisted by Mr.
M. Doctor.
London Counsel for the petition,
9th of
for the
January.
appellants.
9th of January.
On request made on behalf of Gay Gogoi, London Standing Council Higher Education Department. List on 9th.
9th of January. Highly obliged.
May it please you. My lord, by this petition,
Let us rise for 5 minutes. You can tell us. Just 10 minutes will come. Complete.
2016, my lord.
Oh,
Notified by the notification dated 12/8/2021.
where's the rule?
Rule,
You're challenging the virus of
rule, my lord, rule 4,
rule 4.
rule 4, within bracket 2, within bracket B of the Plastic Waste Management Rules 2016, my lord, notified by the notification dated 12/8/2021. Your lordship will find the notification at page 87. Eighty-seven is the notification.
I think this is going to take time. Are you going to take time? How long will you take?
My lord, about 1 hour I will take.
Chaudhary?
If it takes 1 hour, at least half an hour.
The issue is this, ours, this bench is,
Lordship may take it any other day. For me, there is no urgency. I do not know about it. Because this is something the rules have been, the original rules came into force in 2016. There was an amendment in 2021. And this writ petition has been filed in 2022.
22.
22.
Yeah. But
She may
even though
take it
no
in
is,
the month of January.
but,
Lordship.
no, my lord, even though no stay was granted by this honorable court, let it be fixed in the last part of this month prior to closure of the court.
I think that would be a motion we
Ah,
can
that
also.
last week will be a motion late.
As your lordship may.
Okay, heard, Mr. Okay, I'll just say on request of the parties. Means in the month of January 2025.
My lord, the particular date may kindly be fixed.
You want a
Possible.
date? Okay. After Bihu
Lordship.
or
Yes,
before?
after.
21st?
That's fine, Lordship.
Right. Much.
Daily list admission.
Lordship, on the last occasion, the respondents had submitted the select list, Lordship. If they have to make any more submissions after that, we can complete our part. Lordship.
The Standing Council Health Department was not present the other
Yes,
day.
Lord.
That we require.
That's informing.
Just call them. I think you've already notified, no?
No.
Lordship, in that case, could it be taken up at 2 o'clock, Lordship?
Okay. that's no-
Much of it.
Okay, too.
2. Hearing.
Please, Lordship. My senior friend had just gone out to, as per Lordship's direction, call the standing council.
Okay.
He has prepared the written argument
Hmm.
in this matter.
Hmm.
Matter has been conclusively argued by my senior, Mr. P.K. Tiwari, my learned senior, for the petitioner. My senior friend has prepared a written argument. And I do not have a written as of now the matter. But be that as it may, the Lordship permits, me and my friend for the petitioner can submit the written argument on a date that your Lordship may fix. In the meanwhile, my friend can submit his written argument. The matter is,
On the same day you've submitted.
yes, yes. On the same day.
Then when do we fix it?
Any date to be spoken to column your Lordship can have the right.
Not when we'll keep it in this list, hearing list. But on the day when it's listed,
Yes,
you can update it and then we can
furnish
finish.
written argument accordingly. Yes, yes. But we can make a mention in the morning that
But Mr. A.R. Gogoi, learned counsel for the petitioner, also heard Mr. C.K.S. Barrow, learned government advocate for the respondents 1 and 2,
Yes, Lord.
and Mr. M. Sharma for the respondents.
4, 5 and 8, Lord.
How about the other respondents?
They have not entered appearance in the matter.
Notice is complete,
No,
they have not
okay.
entered.
Okay.
They choose not to enter. Okay. Anyway, your argument will
Yes,
cover
yes,
the
yes,
matter.
yes,
I think.
yes.
When? Can we finish it this year?
Yes, Your Lordship.
See, because next week is the only week.
No,
If-
yes, the last week will be a motion day. Only my junior friend needs to be present in the court for that.
Yes,
we will submit it, Your Lordship.
if
It
on 16th, we'll submit it on that day.
itself, we make a mention in the morning.
We'll make a mention in the morning and we'll submit it. Can you finish it? By six?
Lordship, I have.
Shama?
Yes, yes, yes.
What's all this? I will let you know. Begum?
Lordship is there.
Invitation card.
No, Lordship.
So there's no adjournment unless we get it.
I will.
Correct.
There is time, my lord. Only that will come.
Okay, heard MS and Begum let it come. On request made on behalf of A. Chalia, Sunday Council Health Department. When do you want?
Well, next day, my lord, any day, Lordship may fix it, I will appear.
Oh, you left it.
I will appear. Any day,
After 10.
Take a,
अपने बोले तो अपने जिक्र देते थे लोगों को।
oh, any day convenient, please, honorable.
Yeah. Mahanda, somebody is getting married.
Somebody is getting married.
So we can't take up the message.
Oh, this is a very.
Next week, only,
Yatibo kyo nagala? I have come for this only. No.
Chalia is getting married on 10th.
On 10th.
Though I've not got,
No, I will.
though I've not received the invitation card.
Well, we have not been extended the invitation. Otherwise, we would have come to know.
No, I'm saying subject to receiving of invitation card. We can adjourn the matter today. But this has been lingering on for quite some time.
No, I will, that's why I will appear.
But something.
Except 10 mile or any day convenient.
It's convenient to anyone. See, the last week will most probably would be a motion week.
Yes.
Most
He is appearing. He
So-
can appear before 10th also.
Before 10th, it can be before 10th, my lord.
Yes, yes.
Today is what?
This,
Today is 5th. Today is 5th. So
12.
it can be
Yes.
on 12th.
Yes, ma'am.
12th.
Well.
Himugane Durala. Himugane Durala. I had to
Yes.
come for this matter, my lord.
I
only
apologize.
for this one.
At least they should have transmitted the message to us that such a situation. Because I thought that this is part of matter. Let it be finished.
Okay.
My lord, on 12th, I will appear.
12th is part of.
Okay, to compensate the Mahandas coming to court all the.
Yes, yes, my lord. That I
Let us
will.
all have a cup of green tea in my champagne.
So kind of you.
Come.
Thank you. I'm coming.